Good afternoon. I am Professor Wachtler. I'm an adjunct professor at Touro Law School. I teach pretrial litigation, and it is my honor today to be talking to His Honor, the Honorable Sol Wachtler, former Chief of the Court of Appeals of the State of New York. We're going to be talking today about appeals, the Court of Appeals, the process and jurisdiction. I know that sounds like a lot, but it all sort of folds into a discussion about that. So let me introduce Judge Wachtler, and perhaps, Judge, you can say a few words about yourself, especially in your time on the Court of Appeals, which was extensive, and the experience there.
Thank you, Lauren. Thank you, Professor. My claim to fame is to be the father of Professor Wachtler, who has taught me more about trial practice than I learned after being on the bench for 25 years. I started my career as a trial judge. Before that, I was a town supervisor, with my experience being mostly in municipal government. I became a justice of the Supreme Court in the 10th Judicial District, Nassau County. And then after serving 5 years on that court, I was elected to the New York Court of Appeals. That was 50 years ago. The New York Court of Appeals at that time, or the judges to that court, were elected. Today, they are appointed, but we'll get to that in a moment. I served on as an associate judge of the court for 12 years, and then was appointed, because at that time we changed to the appointed system. I was appointed chief judge by then Mario Cuomo, and served in that capacity for 10 years. And so I've had a great deal of experience as being a judge on that court. It was then, and I think today, the finest common law court in America. It consists of 7 judges. Today, all of the judges are appointed. As I said, in my day, they were elected. And so in order to get on the Court of Appeals, you didn't have to be brilliant or extraordinarily talented. You had to be electable. And so both political parties would nominate candidates, and the candidates would run statewide. And if you were fortunate enough to be elected, you were privileged to sit on that court. The appointive system, that is merit selection system, which is now in effect, although being challenged, would permit a nominating committee, a judicial nominating committee, consisting of 12 persons, appointed bipartisan by the Democratic and Republican parties, lawyers, former judges, and non-lawyers, to review the qualifications of those who apply to sit on the court, and then submit a list to the governor, and the governor would select from that list the judge to sit in a vacancy on the court. Also appoint the chief judge. When I was appointed chief judge, as a member of the court, the governor then appointed another associate judge to take my seat. Basically, Professor, that's my background, and the background or the genesis of my service on the New York Court of Appeals.
One of the things that I think people find a little bit confusing when we talk about jurisdiction and we talk about the structure of the courts is that we have the Supreme Court, which is actually not the court of last resort in New York, whereas it is in so many other states. I think there may be one other state that has a higher court than their Supreme Court, which may be Massachusetts. So that leads me to a question about jurisdiction, notwithstanding the fact that it's called the Court of Appeals and that's your court of last resort. But can you speak a little bit, Judge, about the jurisdiction of the Court of Appeals? Because a lot of people get confused between the appellate division and then the Supreme Court, which is below the appellate division, and then we go to the Court of Appeals, which is our court of last resort. Can you speak a little bit to the jurisdiction of that court?
Before I get there, though, I'd like to just mention the fact that the confusion in our 11-layered judicial system in New York State doesn't just exist with respect to the Court of Appeals. I was speaking at the Chautauqua Institution back in 1985, and it was a very large audience, and I was discussing the jurisdiction of New York State courts, and I said that if anyone in this audience can name every court in New York State and the jurisdiction of that court, I would give that person $100,000. Now, I didn't have $100,000, but I was certain that I would have no takers. And as a matter of fact, if I did, and they were able to name all the courts, I wouldn't know whether they were right or wrong, because although I was chief judge of the state of New York at the time, I didn't know then, and I don't know now, all of the various courts in New York State. It's that confusing. And if you think you do, then tell me, what is the Recorder's Court in Albany? If you know what the district court is in Suffolk County, you can say, well, it's the same jurisdiction as the district court in Nassau County. But if you cross the line into New York City, you would find there is no district court. Now, we know that the county court in Nassau and Suffolk County has jurisdiction over major crimes. But if you go into New York City, which is just across the border, there is no county court. The jurisdiction for major crimes resides within the state Supreme Court, which, as you know, is not supreme. The Court of Appeals is. But appeals from the district court go to the appellate term of the Supreme Court, not to be confused with the appellate division of the Supreme Court. And then you have to also discern the difference between various trial courts, the family court, beyond the district court, surrogates court, Supreme Court. I'm not going to take up any more time with that, other than to say that, as the professor has pointed out, the court of last resort, our Supreme Court, is the New York Court of Appeals. The only other state which has that breakdown as far as nomenclature is concerned is Delaware, which has its high court is the Court of Appeals. And in Massachusetts, it's called the Supreme Court of Jurisdiction. So
And
let's
just
concentrate.
to break in there 1 minute with the appellate term, which is very confusing because it is an appellate court from the district court, not the Supreme Court, that some of the Supreme Court judges sit as appellate term judges. So if you think, oh, great, I'm getting away from this judge, may very well be that that judge is sitting the appellate term for your appeal to just make matters worse.
Well, just by the same token, the appellate division, which is the interim appellate court, is made up of Supreme Court justices appointed to the appellate division by the governor. Okay, so now that everyone is probably either dozing off or totally disinterested, let me talk to you about the Court of Appeals. As I noted before, the Court of Appeals is made up of 7 judges. All courts of last resort in every state have an odd number of judges because as the appellate term in this state has 3 judges, the appellate division can sit in panels of 5 judges, Court of Appeals in 7, the United States Supreme Court in 9, so that you can't have an evenly divided court. However, and unfortunately, sometimes you have a court of 7 judges, like our Court of Appeals, and you'll have a majority opinion, and then you'll have a concurring opinion, then you'll have a dissenting opinion, then you'll have another opinion which concurs in part with one dissent and in part with one majority. And after you finish reading all the tea leaves, you have to decide, what is the court really telling us? What is the law? Which is one reason why up until recently, the chief judges used to struggle with trying to achieve unanimity on the court, or at least a 5-judge majority, so that the rulings would be more clear. But let me get into it. You know, it's so difficult to make a subject like this interesting. I can't even maintain interest in what I'm saying.
I'm finding it interesting.
But let's say that you've won your case in the Supreme Court, but your opponent, or that is the party which loses, seeks leave to appeal to the Court of Appeals. Now, that's one way to get to the Court of Appeals. You have an automatic appeal to the appellate division, which is can sit in panels of 3 or 5, and that's a division of the Supreme Court. Our appellate division, that is in Suffolk County, Nassau County, Westchester County, Rockland County, Brooklyn, Queens, the largest appellate court in the United States of America, and probably the largest in the world, is the Second Judicial Department. That is the Appellate Division, Second Department. That's where the immediate appeal goes to. And let's assume that you won in the court below, and you go to the Appellate Division, and the Appellate Division decides in your favor. Well, you say that's it. But no, it's not it, because your opponent has to, or has the ability to apply for leave to appeal, which, going back to my first hypothesis, was that I had won the case, but now I find that my opponent is seeking leave to appeal. Now, to seek leave to appeal, you file briefs with the court saying that you believe that the lower courts made an error, that the lower court ruled improperly, that the jury decided the case for or against you based on an improper charge to that jury. And so you want to go up to the Court of Appeals. If you won or lost in the lower courts, you might find yourself opposing a motion for leave to appeal or being the author of the motion for leave to appeal. So now the Court of Appeals gets these motions, and perhaps 3,000 a year, and it has the obligation of deciding which appeals it will hear. That makes it a certiorari court, just like the United States Supreme Court. The United States Supreme Court will not take every appeal filed. You have to have leave to get to that court, and that's the same with the New York Court of Appeals. Now, when the motions come in, they are distributed to all of the judges on the court. You might have 40 in 1 month. But thankfully, and we didn't have this when I was on the Court of Appeals, thankfully, they now have a central staff, which is made up of young law school graduates who go through these motions and then file a motion report, which they give to the judge who was assigned that motion. And the motion report recommends either that the motion for leave be granted or that the motion for leave be denied. And then the judge who has been assigned that case will circulate that motion report to the other 7 judges and voice his or her opinion as to whether leave should be granted. The other judges then vote. And if one other judge agrees with that reporting judge, leave will be granted to the Court of Appeals and set down for briefing and argument. But in 90-some-odd% of the cases, the reporting judge will probably recommend that leave not be granted. That doesn't mean that another judge who has read the motion report might not say, whoa, I think it should be granted. And if that judge can get another judge to agree, then the motion will be granted. So, whereas it might sound complex, it's a rather easy and working process. Now, I just received today the decision sheet from the current Court of Appeals, and it tells me, this is dated March 21st, it tells me the disposition of all the motions that were made prior to that date and how the court disposed of those motions. Let me read just a couple. Appeal dismissed upon the ground that the issues presented have become moot. In other words, during the process of seeking leave to appeal, the defendant may have already served his term, which might have been just brief, or the case that was being disputed and appealed may have been settled. There could be any number of reasons why, even though the motion was accepted, the case is disposed of before the motion could probably be decided. And so the court says it's moot, so we're not even going to look at it. Here's another entry. Re-argument ordered for a future court session. Now, that means that because the court now only has 6 members, apparently there was a split, a 3-3 split. So the court said, we'll grant leave in this case, but we're not going to have we've already had the argument, but we can't agree. It's 3-3 split. So therefore, we're going to, on our own motion, grant a re-argument of the case after we get another judge appointed, which is still in the process in Albany. I'd like to read one other entry. Order insofar as appealed from, granted. And the case is remanded to the appellative term First Department for determination whether defendant's sentence is unduly harsh or severe. Now that's very, very unusual because the Court of Appeals in the past never reviewed an act of discretion on the part of the lower court. And that act of discretion is sentencing. So that the Court of Appeals never, up until, I think this might be the first entry I've ever seen of this sort, never have said, well, we think that the sentence is too harsh. The reason for that is because the judges sitting on the Court of Appeals never saw the witnesses. They never heard the testimony from the victim or the victim's family. They never saw the probation record of the defendant. They just apparently, members of this court just felt, ooh, that's a lot of time for someone to spend. And so they decided to send it back to the appellate term to give it another look. And then if the appellate term says, we saw nothing wrong with the decision, which probably came from a district court, or which may have even come from one case, the Court of Appeals accepted the review of a parking ticket, Suffolk County, saying that the fellow who was ordered to pay a $50 parking ticket wasn't given due process. And even though the appellate term agreed and set aside the $50 fine, the New York Court of Appeals saw fit to grant leave because it feels, or it felt, that it should be able to exercise interest of justice jurisdiction. Now, before I go any further, I would just like to explain what I've just been talking about. The New York Court of Appeals in the mid-1800s was created, and it was created for one purpose only: not to exercise discretion, not to exercise interest of justice jurisdiction, but to review the matters of law created by the trial below or by the decision below. Issues of law. It will not, or it should not, under the Constitution, it should not entertain matters of fact. So that if a person is convicted of a crime and the jury finds that person guilty and the charge given was proper under the law, or no exception was made to the charge, that is, when the judge charged the jury, no lawyer said, Your Honor, I accept because the charge to the jury didn't properly state the law. Assume that it was a very clean trial record, no exceptions, no objections preserved, and we'll get to that in a moment, a clean appellate record. Now, the lawyer feels, my client should not have been felt guilty under the facts which were allegedly proven. I'm going to go to the Court of Appeals. No, first I'm going to go to the appellate division. Well, the appellate division says, we find no problem with the facts found because the facts found were supported by the evidence, and we're not going to interfere with that. So the defendant says, well, maybe you're not, but I'm going to go to the Court of Appeals and have them look at this record. Well, when it goes up to the Court of Appeals and they seek leave to appeal, in criminal cases, you only need one judge to approve the appeal. The Court of Appeals is going to say, or should say, we're not permitted under the Constitution to look at the facts. We're not permitted to look at anything in the trial below that wasn't preserved for our review, and the professor will explain that in a moment, or we're not going to review a charge given if there was no exception made to the charge. We are only here to review points of law. So goodbye. And in addition to that, if there is an affirmed finding of fact, that is, if there's a fact found by the trial court and affirmed by the appellate division, That's the end of the case as far as the facts are concerned. We cannot, or the Court of Appeals cannot, find new facts. The Constitution doesn't allow it to do that. Now, there have been recent dissents in the court by judges who feel that we should be given, or the Court of Appeals should be given, that additional jurisdiction, that the Court of Appeals should be able to do what the appellate division can do, and that is find new facts. The appellate division can also review the discretion of the trial court. So if the trial court dismisses a complaint, the appellate division can say, no, that complaint has to be reinstated because it was a properly made complaint based on an indictment that was properly handed down by the grand jury. Now, let me give you an illustration. Bernard Goetz, the subway vigilante. I don't know how many of you remember that case, but it was the first case, or one of the first cases, that the court on which I presided had to decide. Now, Bernard Goetz was a folk hero. He was called the subway vigilante. He was on a subway car, and several African-American youths confronted him and asked him for $5. And he was fearful. And so he took out an unlicensed weapon and shot them. One of the young men was on the floor, struggling, and Goetz went over to him and said, I think you need another one. And he then put the gun to the spine of the young man and shot him, crippling him for life. A grand jury met and didn't indict him for anything because he was a hero. The New Yorkers loved him. They made him, he could have run for mayor and been elected like that. Because people were fearful in those days. You think the crime is rampant in the city now? In those days, we were having the crack epidemic. We have today 30,000 people in our state penitentiaries. During that crack epidemic, we had 110,000. We complain about Rikers Island being overcrowded, which it is. It's a hellhole. Rikers Island now has close to 6,000 to 7,000 inmates. In those days, it had 27,000 inmates. They had to bring up 3 barges from the Falkland Islands that were used as British troop housing to park them next to Rikers to take the overflow of prisoners. And so when Bernard Goetz had shot one of those marauding gangsters, he was applauded. The grand jury didn't even indict him, but the district attorney said that the grand jury was not given the proper instructions, and he asked for permission and was given permission to bring the Goetz case before another grand jury, which did indict him for attempted murder and unlawful possession of a weapon. Then the trial was scheduled to begin on the true bill, on the indictment, and the sitting judge said, I don't think that he should be tried for attempted murder. I'm going to dismiss those charges. And he was hailed as a hero. But then the district attorney took an appeal to the appellate division, saying the trial judge ought not have dismissed those charges. And the appellate division said, no, we think that those charges should be dismissed. And so the district attorney sought leave to appeal before the Court of Appeals. And we granted leave because we saw no basis for the dismissal of an indictment. And the case was argued. And we decided by a unanimous decision that Getz had to be tried for attempted murder. We were vilified. They said, how dare you do that? And we said, we can rule on matters of law. And as a matter of law, this was a valid indictment which should have been tried. We don't care about whether he's a hero or not, or whether he's innocent or guilty. We have to follow the law. As it turns out, he was tried for attempted murder, and he was acquitted. But we did our job. When the sodomy laws were challenged, the lower courts all held that the state legislature was perfectly correct in passing those laws and enforcing them. But there was a case raised where two consenting males were caught having sex in private place. And so an appeal was brought. They were convicted under the sodomy laws, and an appeal was brought directly to the Court of Appeals, because another way to get to the Court of Appeals is when you challenge a constitutional provision. So if you're challenging the sodomy laws or the death penalty or something else which is profoundly ingrained in our constitutional protections, you can go directly to the Court of Appeals to have your appeal heard. And that's what Mr. Onofre did in the case of People versus Onofre. And our court set aside, and this is back in 1980, set aside New York State sodomy laws. And we were again vilified by the public because they said we, the Court of Appeals, were responsible for spreading the AIDS epidemic. I'm telling you these only to indicate that this is the beauty of having an independent court of last resort, because it doesn't matter what the public wants or what the public values are. There's a piece that I wrote in today's Law Journal that I would refer you to, which has to do with this very subject. So the Court of Appeals, again, has jurisdiction over a preserved issue that was preserved as a law issue in the lower courts, and it has jurisdiction to rule directly on constitutional violations. But you could say, well, every time there's an illegal search and seizure, that's a constitutional issue. I mean, it violates the Fourth Amendment or Article 1, Section 8 of the New York Constitution. But our court decided many years ago that when the Constitution said a constitutional issue or a law issue must be raised, it was talking about a substantial constitutional issue. Now, that might sound kind of an amorphous standard, but it's one that has been polished and honed through years of precedence. And the Court of Appeals is able to judge whether or not, in reviewing a motion, whether or not the leave is being sought on a substantial constitutional issue or merely on an alleged error of law. Now, if it's an alleged error of law and that error of law is deemed worthy of review, leave will be granted. But if the only error is that my constitutional rights to search and seizure were violated, you say, fine, then litigate that in the lower courts. And if the lower courts make an error of law in that determination, it will be reviewed by us. But you can't come to us and simply say, it's a substantial constitutional question, and therefore I should have the right, as the DA did in the Bernard Goetz case, to come directly to your court. And this particular sheet that I have has dozens of entries which simply say, motion for leave to appeal denied inasmuch as a substantial constitutional question is not raised. And then it goes on to say, motion for poor person relief dismissed as academic. So that if the court felt that there was a substantial constitutional issue raised, like in the Onofre case, it would grant leave, and it would also grant leave for appeal as a poor person, so that the person who was seeking leave wouldn't have to raise the money to pay for a lawyer and pay court costs in order to have the court hear it. Now, as I said, the court constitutionally can't review acts of discretion. Now, what are some acts of discretion? Sentencing is an act of discretion. Now, if the law says that a person can only be sentenced between 2 and 5 years, and the court below sentences him or her to 6 years, then that is a reviewable issue. Why? Because the court has acted against the law by imposing a sentence of 6 years instead of 5, because the law says you can't sentence over 5. So it's a question of law, which the Court of Appeals, will review. But if the sentence was 5 years and the fellow sought leave to appeal because they said it was too harsh, the Court of Appeals will say, we feel very sorry for you, but we don't have the power to review a discretion or a discretionary act by the lower court.
Can I ask a question here about that?
I'm sorry.
Yeah, I wanted to ask you, you said the other case that, about the traffic ticket, where he was ordered to pay a fine, and the court said the penalty was too harsh, which it would indicate that they were determining an act of discretion was not appropriate, which is not within the jurisdiction of the Court of Appeals to review. Was it possible that perhaps the fine or the penalty or whatever it was that was sentenced was not within the statutory scheme for the court to actually impose that penalty, which is why the Court of Appeals took that position, or not?
No, actually, that's an excellent question, and it only reflects the fact that I didn't state what happened properly. In that particular case, leave was granted, and all the judges agreed, except one. All of the judges agreed that it was not reviewable. It was not reviewable. But one judge wrote a dissenting opinion, a rather lengthy one, which said that the Court of Appeals should be able to review discretion and should be able to act, quote, in the interests of justice, close quote. Now, again, the trial courts can exercise discretion and interest of jurisdiction application. The appellate division, the appellate term, they can all do that. Court of Appeals can't. And so this particular dissent, and this was just handed down, I don't know, not too long ago. This particular dissent said, we should be able to do that because we are the court of last resort. And if we're the court of last resort and we can't administer justice, then we shouldn't be in business. Well, with all due respect to that dissenting judge, the fact is that it's against the constitutional provisions, and all of those are there for a reason. We can't have the court of last resort simply reach down and take appeals because we feel that there was some abuse of discretion or that justice wasn't heard. No more than the United States Supreme Court could do that. You just can't, we have 3 million cases, 3 million cases processed through the New York courts every year. The busiest unified court system in the world. And we're going to say that the 7 judges on the Court of Appeals should have the power to review every single one of those cases or the final determination of every one of those cases. We will say that if there was an error of law or if due process was not administered, yeah, we will review that. But we just can't. Learned Hand, who was one of the most brilliant jurists ever to serve in this country, made a speech about this up at Harvard Law School. He said, every single day, there are some abuses of discretion in the traffic courts, in the municipal courts, in the trial courts. The court of last resort just doesn't have the time or ability or expertness to review every one of those cases. So what it does is have constraints on its jurisdiction. And the constitutional constraints say that we have limited jurisdiction. So to answer your question, Professor, the Court of Appeals did not exercise its discretion, nor should it have, I believe. But that's a tussle that's going on right now in the Court of Appeals, because I just read you an entry, which I hadn't seen before, where they're sending, they feel that a sentence administered was too harsh, apparently, and so they're sending it back to the appellate term to give it a second look. And if the appellate term gives it a second look and sticks with the same sentence, then the court might schedule it for re-argument and set aside the sentence, which would absolutely open the floodgates and will no longer have a Court of Appeals which has very limited power.
And that would be the case that would set the precedent for everybody seeking leave for a review of facts.
Exactly. Exactly. Now, let me tell you the other good reason for the court's limited jurisdiction. Not only does it preserve the court as an entity which would review serious errors of law to protect the rights of all of our citizens, but it also prevents the court from being given unbridled power. Let's assume that the court decides that we have mass incarceration, which we do, and that it impacts mostly minority members of our community, which it does. And so the Court of Appeals, in its wisdom, decides that anyone who is found to be impoverished should not be sentenced to prison. If you gave them the power of review, it could do that. We had the Court of Appeals just reverse a conviction of a rapist. And these are the facts. A woman was raped, brutally raped, and reported it to the district attorney. The district attorney had all of the, they call it a rape kit made up, examined by a hospital, and DNA samples were taken. And it was found about 2 months later, they have the suspect. Why did it take 2 months? Because, number one, the district attorney didn't take her seriously enough when she reported the rape, thinking that it might have been a consensual act. And secondly, they said they were too busy conforming with the new law, which required district attorneys in discovery proceedings from turning over tons of papers to the defendant's lawyer. Just today, because of this particular case, just today, Governor Hochul has proposed legislation to ease up on the burdens imposed by district attorneys, because district attorneys were having to dismiss cases that they couldn't get to because they had reduced staff, which couldn't go through all the paperwork necessary to provide the discovery items to defendants on trial. As a result of this, there's been a 44% increase of dismissed cases because lawyers who properly are representing defendants have made all of the demands possible for discovery items to be turned over. They have found that DAs have been delivering items and files by the wheelbarrow full, and the defense attorneys haven't even looked at them, but they are doing what they should do. They are representing their clients and trying to get their clients free of the criminal justice system. And so the best way to do that was to demand all these items. Well, let me come back to the case that was just decided by the Court of Appeals a week ago. The legislature, in order to allow for these lapses, declared that there's a 5-year statute of limitations on rape charges. Now, well within the 5-year period, this district attorney matched the DNA, had a trial of this defendant, and the defendant was convicted. The defendant then sought leave to appeal to the Court of Appeals because the defendant claimed that the New York Speedy Trial Rule, which our court imposed, was not met, that there was a 31-month delay on the part of the district attorney of getting from indictment to conviction. And so the Court of Appeals, a divided court, ruled that this convicted rapist should be set free and the charges against him dismissed because of a violation, not of the statute of limitations, but of the Speedy Trial Rule. And that's why today, Governor Hochul has said to the legislature, you got to change the law that you imposed in 2019, which required the DAs to give their whole offices up because there should be a prior showing of the necessity for this discovery by the defendants. And by necessity, we mean that the DAs cannot withhold Brady material, which they never could, et cetera, et cetera. Now, I don't know what's going to happen with that legislation, but it's tied up today in budget negotiations up in Albany. Any other questions?
I'm just following up on that a little bit because it's of interest, even though there is so much more that I want to talk about, not on that subject. But what happens when, and in that case, the charges were dismissed. So the alleged rapist or convicted rapist now is free. And what happens with this legislation? Does it impact? It hasn't been passed. Nothing has been passed. It might sit there forever. So does that mean that pending any determination of whether or not the legislation should be changed, we continue along the same path and the district attorneys are required to do whatever they're supposed to do? Is there any remedial action that can be taken to correct what seems to be an egregious wrong, at least against the woman who was raped? Especially, it's not alleged anymore. He's convicted.
But the defendant doesn't think it's an egregious wrong. And I must tell you that the defense bar does not think it's an egregious wrong. They think that a person has a constitutional right to a speedy trial. And by the way, that rule came out of a case which we decided from Suffolk County, where the district attorney of Suffolk County kept someone in prison for a couple of years before that person was finally tried. And that was dereliction on the part of the district attorney. And an innocent person should not be kept in prison for 2 years because the DA just doesn't get around to trying the case, no matter how guilty the defendant is. Even if the defendant, and I think in that case he was a murderer, even if the defendant's a murderer, he's presumed innocent until he's found guilty. But to answer your question directly, yes, this will continue. And I think it's definitely an abuse on the part of the defense bar. It's an abuse, but as advocates, their job is to do whatever they can to keep their client, their defendant, out of prison. And so they use that device. Hopefully, the legislature will roll back its 2019 legislation. Another piece of legislation that's now being hotly debated, the reason why our budget is not passed yet, it should have been passed on April 1st, is because of the bail laws. And I don't want to get into that, except just to note parenthetically that we have prisoners in Rikers Island who have been held there a year or more, even though they're presumed innocent, because bail has been set, which, even though small in amount, cannot be met by these prisoners. Now, there's a big debate going on. Should judges, when they set bail, consider dangerousness, or is that not to be a factor? In other words, if there's someone in Rikers who has been accused of shooting someone and he was arrested with a weapon on him, should the court only consider whether he'll be available for trial in 2 months? Should the judge consider whether he has a good family to go back to? Or should the judge consider, I'll consider all those factors, but I also want to consider whether it would be dangerous to let him out on the streets. And so that becomes another subject, which is now being debated in Albany. But
I think what we've learned from all of this is that there is quite a delicate balance that must be considered between the various branches of our government. They need to be kept separate. They need to be kept distinct. People need to understand what the jurisdiction of the court is as opposed to the jurisdiction of the legislator, as do judges and the legislators themselves. And I think that as the students and as people who are watching this podcast come into their own in terms of the law and their practice, that's something that has to be considered, whether you are writing a brief or arguing an appeal or determining whether or not you can or should seek leave to appeal to our highest court. So I'm hoping that maybe we'll be invited back to do something on the actual arguments, some of the things that people should consider if they do get the opportunity to argue an appeal in the Court of Appeals, and the difference between certain benches, a hot bench, cold bench. We don't have the time to do that, but I certainly would love to revisit that if the law review asks us back. So with that, I will thank.
I want to thank you very, very much, and very much for the opportunity. I would just like to end on one note, if I may. Benjamin Cardoza, who was our chief judge in the New York Court of Appeals, wrote a treatise called "The Nature of the Judicial Process," and in it he poses a question, and I would love to leave with this question. He says, the New York Court of Appeals is a strict law court. Now, what do you do with this case? The New York law says that a person who leaves his estate to another person, that the other person has a right to inherit that estate free of any encumbrances imposed by the law. So John Jones writes a will leaving his entire estate to Bill Smith. Bill Smith then shoots John Jones, murders him in cold blood. Does a court of law say, so what? We only review the law, and therefore the inheritance goes forward? Or does the court say, wait a minute, how can we let a person profit from his own misdeed? So think about that. Thank you very much, Professor.
And thank you, Judge. And thank you to Touro and Alexa Russo for inviting us.